Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division. You are near, give your attendance, and you shall be heard. Please be seated.
So good afternoon, all. Welcome to the Appellate Division, First Department. We have arguments for today, September 30th. We have 6 hours of argument time requested, so please only ask for the time that you actually need in order to get out the salient points of your arguments. We are fully familiar with your briefs. Excuse me. Also, please keep in mind that the light is for you, not for us, so that if we do have additional questions, we will certainly ask them. People v. Lantigua Gibbs. That matter is submitted. Liberty Mobility versus Port Authority.
Appellant, 10 minutes, 6 and 4. Good afternoon, Your Honor. Respondent, we respectfully request for 15 minutes.
Certainly. 5 and 2 and 5. Matter of Michaela is submitted. Lima versus 1148 Corporation. I'm sorry? Yes.
Respondent requests 8 minutes, please.
6 and 2 and 6. McGregor v. Manhattan Nursing Home.
Appellant requests 5 and 2.
Is there a respondent? Did you still wish to argue?
I actually do, Your Honor.
Okay, 5 minutes. Bennington versus Solomon Guggenheim Foundation.
Respondent requests the full 15, Your Honor.
7 and 2 and 8. That matter will be called first. People v. Marte. So no one paid attention to what I stated about the salient points of your arguments, right? 5 and 2 and 5. Suarez v. the City of New York.
Plaintiff appellant, 5 and 2, please.
Respondent 3.
5, 2, 3. Ancart v. Cresbow.
Respondent. Appellant here, Your Honor. We can make the points of 5 and 2. Your Honor, 2 minutes.
5, 2, 2. Flores v. New York State Office of Children. That matter is submitted. Matter of our children. That matter is submitted. U.S. Bank v. Turbicio. That matter is submitted. Gamble v. MTA Bus Company. That matter is submitted. Owen v. Johnson.
Good afternoon, Your Honors. Requesting 8 and 4, please.
For respondent, 6 and 3, please.
6, 2, 6. You have a cross motion?
No.
6 and 2 and 6. Godfrey Peters versus D'Angelo. 3, 2, 3. People v. Johnson. That matter is submitted. Malicon versus Malicon. That matter is submitted. Allman v. Kimmel. That matter is submitted. As I stated, the first case for argument is Bennington versus Solomon Guggenheim Foundation.
Step up.
May proceed.
Good afternoon. May it please the court. Yael Whites on behalf of appellants. The lower court erred for 2 reasons. First, the court incorrectly held that direct Nazi involvement is necessary for a finding of duress. This ruling contravenes both New York case law and U.S. policy governing claims to artworks lost during the Nazi era.
Is there even any indirect Nazi involvement?
No, Your Honor, there is no indirect Nazi involvement, but here, under New York case law, that is not required for duress to be considered a form of Nazi confiscation and for the sale to be void.
But the first time did anyone on any of your parties seek to do anything about this work of art?
In the year,
When was the first time that there was a claim made for it?
here, appellants made a claim or rather the actual knowledge required under the HERE Act for the claim was in October of 2016, and under the HERE Act, the actual knowledge of the claimant is what governs.
Was there knowledge of the, where the painting, or who possessed the painting? Was there knowledge of that prior to 2016?
Adler's knowledge, we don't know that Adler knew where the painting was at the time that, let me rephrase. Adler had died before the painting went to the Guggenheim. In this case, the Guggenheim did send a letter to Adler's son with respect to its possession of the painting.
What year was that? What year was that?
1974.
1974.
I believe. Yes.
And at that time, that was Eric Adler that received that letter, right? That was the son,
That's correct.
and he confirmed the times during which the family owned the painting and approximately the time when it was sold. But they never pursued anything after that, did they? Eric Adler or any of his family members never pursued anything. And that was a letter from the Guggenheim, wasn't it?
It was a letter from the Guggenheim, but the lower court erred in placing any weight on this letter.
Well, did not the letter confer knowledge? Or would the letter gave knowledge to Eric? I think the point was that Eric knew in
1970-something.
what year was that?
73.
73, concerning the painting, right? And he responded that his parents had purchased it in 1916. They kept it until 1939. And then he never said that there was any issue in terms of the, we'll say, sale of the painting.
The letter answers the direct question from the Guggenheim, which was intended to confirm its own basic cataloging and information about.
But at that point, that letter means that you knew where the painting was.
It only goes to, sorry. So it doesn't indicate, though, that Adler knew anything about the circumstances of his father's sale.
Sure, didn't he state when it was purchased, when it was sold, who it was sold to?
It merely stated that his parents had acquired it in 1916 and kept it until 1939. That is
Right.
correct. But that information should have raised bright red flags for the museum. The museum is not
Should
an
have raised red
bright
flags
red
for
flags
the museum?
For the museum, that's correct, under Lubell. And
Why
as
should
a-
it have raised red flags for the museum? Simply because of the dates involved?
Absolutely. 1939 is a bright red flag. This is the year that World War II commenced.
But Eric never stated anything in this conversation. He stated that the painting had been sold to Thanhauser. I mean, I think Thanhauser was the one who, was he the one who was sold to, or was he the one who handled it?
I think it was sold to him.
It was sold to Thanhauser. So Eric in this conversation never said that there was anything about transition of ownership of the painting or anything about it.
The letter answers the direct question, but claimants like the Adlers could not have known of this kind of claim and that duress could be considered void as a form of Nazi confiscation until many years after the war. And in fact, expert testimony will show at trial that there was no avenue for them to even bring this kind of claim for many years
In
thereafter.
1973, wouldn't you know, or 1974, when they get this letter from the Guggenheim, wouldn't that be an indication to them? Well, maybe there was duress or something like that? I mean, and then from 1973 till 2016, you do nothing about it?
The letter doesn't indicate what Adler's son knew or didn't know. And museum is in a different position than an ordinary non-merchant. And they were warned, museums in the United States were warned by directives and policy statements and warnings from the government about Nazi confiscated art and art that was misappropriated during the war era.
You know, I would agree with you. However, the same knowledge that you're imparting to the museum concerning Nazi Germany and the Holocaust, et cetera, Eric was aware of this. Eric knew what his parents had gone through.
Respectfully, Your Honor, we can't read that into the letter. And in fact, the whole purpose
We
of
can't
the
read that into the letter.
No.
But we don't, I mean, we don't, do we need the letter for that? You're imparting certain knowledge to the Guggenheim. But what I'm saying is, you're saying that 1939 is a bright line, but Eric also knew what happened with his parents. He knew that they sold the painting in order to use the proceeds to go to Argentina, et cetera.
I think that is an issue of fact that should be determined by a trier of fact, because with the HERE Act, Congress recognized
What issue
that
of fact
claimants-
do you want determined by a trier of fact?
what Adler and his family reasonably could have known and what they could have done in the years.
And the fact that he communicated when the painting was sold, who it was sold to. I think he also said, you know, my sister or somebody may have more information. If they needed additional information, they should contact his sister. That is insufficient?
Respectfully, I don't believe that he specifically said that it was sold to Tannhauser.
No, but he said it was sold. He said it was, his parents bought it in 1916 and kept it until 1939. Justice Kapnick? You had a question?
Right, yeah.
Justice Shulman?
Yes. I just want to go back a little bit. We know that the original Adler in 1916, who purchased this painting from Picasso, sold it to a family friend because they were I mean, certain information here is not disputed. The Tannhausers and the Adlers were in business historically. We have Justin, who ultimately donated the painting to the Guggenheim. Justin was the son of the original Tannhauser, and it got into his hand after it was sold to go to Argentina. There was litigation in Germany in the 50s where the family sought, I guess, reparations for the expenses of going to Argentina, with the backdrop of this painting not even in the equation. Now we fast forward to 1973, where Eric Adler, a descendant of Hans, who, you know, they say, we're interested, if we have this painting, we're interested if you have others in this collection, and he was concerned about how they even got his personal contact information. That was what was on his mind in 1973. Now, everybody dies, including the curators of the museum, through that ensuing decades. And we have your action in 2016 by really removed heirs and perhaps other charities, and I get all that. So again, this entire backdrop, the central issue here is, given that what was a transaction between two Jewish families, one in Switzerland and one in France, why do you think Judge Barak made a mistake here?
A few points, respectfully. So first of all, with respect to the compensation claim made in the 1950s, this was for expenses that could be presented within a fixed restitution process for certain expenditures during their flight. There was no avenue for bringing a claim for this type of transaction in that restitution proceeding, or generally during this time in the post-war period.
But there were families that did begin some of these actions or claims, or at least searching for some of these paintings a lot earlier than your clients.
I would argue respectfully that they're the exception to the rule. Congress enacted the HERE Act with a recognition that it was a painstaking process for claimants, for victims of the Holocaust and their heirs, and Nazi persecution generally, to piece together claims after the war. And they wanted them to have the ability to vindicate their claims, even though by definition these claims are all going to be old because of the number of years that have gone by. And so you have Congress making a decision and instruction to the court that these kinds of claims should proceed and on their merits.
Definitely. But, we still get back to the fact that Eric was contacted and made certain statements, and at no point during that time, or even a couple of years later, is there any, thought, or perhaps there's something going on, or perhaps there was an issue with the sale? Nothing.
Again, I think that the important point here is that duress as a form of confiscation didn't exist for many years, and really it wasn't until the Terezin Declaration that this became a concept that was familiar to people, and in fact was only recently reaffirmed with the best practices, and you have the HERE Act in 2016. So claimant, the expectation of being able to bring this kind of claim in the years after the war, and for many years after, it just isn't, it's not a historical reality. And at trial, we will be able to show with expert testimony that, in fact, there really wasn't an avenue for claimants to bring this kind of claim in the post-war years. I also wanted to address the point about Tannhauser being Jewish. We don't dispute that he was Jewish, but that doesn't mean that he didn't take advantage of the Adler situation, and that this sale was still under duress. And I think that the sale price here being unconscionably low is a good indication of the kind of duress that he suffered. There's no reason that he would have otherwise sold for that price at the worst possible time while fleeing, not knowing how long it would take to get a visa, right? So these are all indications of the circumstances of duress that Adler felt personally and that he suffered, in addition to the persecution of Aryanization and
What further
and
discovery would
taxes.
there be which would enable you to establish that?
I'm sorry.
What further discovery would there be which would enable you to establish that?
To establish the circumstances of duress?
Yes.
Well, you have to take a look at the financial and historical circumstances would have to be analyzed. We would have, expert testimony showing the pressure and the historical circumstances that they faced, what assets they could have accessed, and I think that there's also the issue of what would have been possible for them to pursue, which I referenced earlier. So there's numerous facts, and there's also just fact disputes that have come up and that were inappropriately decided below.
Thank you. You do have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Antonio Perez Marquez for Respondent, Solomon R. Guggenheim Foundation. What I'd like to start with a point that was raised by the questioning there, which was about what Eric Adler knew or what this particular plaintiff, Thomas Bennington, knew and when. And the key point is that the knowledge of prior generations is imputed to the current claimants. The clock does not reset with each successive generation. And so everything that Adler, Carl Adler himself knew, the facts and circumstances of the sale, his facts and circumstances at the time, the identity of the buyer, the consideration received, that is all imputed. And the first to allege any impropriety in this transaction is the plaintiff, in this case, Thomas Bennington, the great-grandson, 3 generations and 85 years removed from the transaction itself, without any purported basis of personal knowledge, saying for the first time that the sale was improper. There's no allegation that Carl Adler ever took that position, much less that the sale was invalid or involuntary. Now, there are 3 bases on which this case was dismissed. Any of the 3 is sufficient to affirm, and all 3 were correct. but I'd like to start with ratification, on which there was nothing said by my colleague on her argument, and there's very little in the papers. It is black letter law in New York that to invalidate a contract on the basis of duress requires a prompt repudiation. That was held by this court in the Phillips South Beach case. It was also ruled in the Beltway case of this court, that a contract procured by duress is not void, but merely voidable, and it can be ratified either by accepting and retaining the proceeds or by failing to make a prompt repudiation. That's a disjunctive. Either suffices. Here we have both.
But what, the HERE Act that was enacted in 2016, I mean, doesn't that put a little bit of a different twist on the cases that involve Nazi art, whether it completely is involved here or it's completely applicable? Still, didn't it change a little bit the focus of some of these claims?
Respectfully, absolutely not, Your Honor. And the reason is that ratification, like laches, is an equitable defense. And the HERE Act expressly precludes only time-based defenses at law. It does not touch equitable defenses like laches or ratification. And so Congress could have chosen, and in the future, perhaps it may. Right now, the law is that those defenses remain fair game. The HERE Act did not purport to modify their application to these cases, and it did not purport to modify the substantive standards of duress that apply in these cases.
Didn't Rafe v. Nagy change that? And we have case law that what you just said is not necessarily correct in the guise of a situation where there is Nazi persecution.
Your Honor, Rafe v. Nagy did not, ratification was not an issue in Rafe v. Nagy because in that case there was no opportunity to ratify or to repudiate. In that case, the relevant owner, Fritz Grunbaum, was forced to execute a power of attorney while imprisoned in Dachau, where he was continuously imprisoned until he was murdered. So ratification never came up. Our facts are completely different because here you have Adler having sold in 1938, escaping to South America in 1940, living out the rest of his life through the late 1950s without any suggestion that the transaction was improper, invalid, no allegation of any effort to investigate a claim. Now that is dispositive as a matter of laches, which requires diligence. It is also independently.
Wasn't there decades of inaction as well in Rafe versus Nagy?
No, Your Honor. In Rafe v. Nagy, on the issue of laches, the facts were completely different, both on the issue.
That's not my question. My question was whether or not there were decades that passed. I understand that it's a much more compelling circumstance. I don't disagree with that.
On the issue of delay, it was different because the family had pursued, they had been trying to find these drawings, and when they turned up—
How many years passed?
Well, from the sale, it would have been decades by
Correct.
definition. But the key distinction is that during those decades, there were efforts being made to locate the artwork. And once the artwork was located, the family acted promptly. Within weeks, from November to a few days later in November, that when they identified where the artwork was—
You're talking about due diligence rather than ratification now.
It's both, Your Honor. So it's the lack of a prompt repudiation is dispositive as a matter of ratification. The complete absence of any allegation of diligence for a multi-decade period is dispositive on the issue of laches.
So who has the burden on that issue?
I'm sorry?
Who has the burden on that issue?
It is their burden once laches is raised.
I thought that you have the burden on an affirmative defense of laches requires that the person raising that affirmative defense goes forward with that defense.
Well, 2 points on that, Your Honor. Laches is an affirmative defense. We raised it in response to their original complaint in this case. They amended their complaint. They came back. They pled no facts about the location of the painting being unknown or a single measure of diligence during the multi-decade period that this was unknown. And the second point I would raise is that in this case, you have the situation that was discussed by this case by this court in Peters, which is that an unreasonable delay and prejudice apparent on the face of the pleadings. You have an 85-year delay that is utterly unexplained. Their only justification is we didn't know we might have a claim. That is not the standard. The standard is knowledge of the facts and circumstances that give rise to it, and the knowledge of prior generations is imputed to successive generations. And the only legal doctrine asserted in this case is duress. which has existed continuously throughout the period in question. There is nothing in this complaint that would have prevented it from being filed in the 1950s when all the witnesses were alive. And when the court was asking my colleague about, well, what would discovery be? What would the trial be? What was unspoken is what's undisputed, that every witness is deceased. Every relevant witness passed away while they were declining
Isn't
to
that
assert
the
a claim.
same with regard to Reef versus Nagy? All the witnesses had died by then as well?
It's different, Your Honor, because of the lack of prejudice in that case. In that case, there was no prejudice because the owner...
What is your prejudice?
Our prejudice is that we don't have access to any witnesses that would allow us to challenge their assessment of what happened in this transaction.
So
And
that,
it's the
that
same.
would have occurred decades ago. That means unless you brought it in the early 1940s or 50s, you would be in the same position.
That's not correct, Your Honor.
When did Mr. Adler pass away?
Adler passed away in 1957. Justin Tannhauser passed away in 1976 after the museum had reached out to Eric Adler without a single concern being raised in response. And the difference in Rafe v. Nagy was the buyer from whom restitution was sought in that case had bought with knowledge of the claim, had paid less for the work because of the claim, and indeed had bought with title insurance because he knew there was a claim.
Didn't Thalshauser state that you shouldn't tell any relatives of the Adlers about the subsequent either gift or purchase to another individual?
There's a cryptic reference which they make reference to in the complaint. Obviously, we don't have Tannhauser around to ask him what he meant. For what it's worth, I think the most reasonable interpretation is that knowledge of where it came from could make it subject to actual Nazi confiscation. Not that he was the family, it's undisputed, remained in close contact with Tannhauser for the rest of their lives. And indeed, this very plaintiff has pointed in a separate case about a separate painting to Tannhauser's effort to help them recover a different work of art.
When was it that Tannhauser allegedly made that statement concerning "don't tell anyone"? When
Was it?
When did that occur?
I don't have the specific date, Your Honor, but it would have been in either during the war or immediate post-war period.
Exactly. It was during the war, or immediately after the war.
Yes.
Right? It wasn't any time in the 70s or in the 50s.
Oh, absolutely not, Your Honor. There's no allegation whatsoever of any effort to hide the provenance of this work. The museum has done everything right. They reached out to the family before accepting it into the collection. They've repeatedly acknowledged the family's prior ownership in their published catalogs for decades. The painting has been on near continuous display at one of the most famous museums in the world since the mid-1960s, all without them taking any action to recover it during a period which every witness passed away. And if I may, I know my time is up, but just briefly on the issue of duress, Your Honor, because there is no duress in this case. Their claim of exigency in this case is based on economic need. They plead that very clearly.
Well, I mean, the purchase price was low for a Picasso. Is that?
Well, the purchase price is one of the many facts that's going to be very difficult. Plaintiffs themselves have taken multiple different positions as to what the sale price was, and we no longer have access to the transaction participants to ask. But economic exigency, when not caused by the counterparty of the transaction, does not constitute duress as a matter of law in New York. That is full stop, not duress, and that is what they allege in this case. And the notion of third-party duress, that fails as well. That's a doctrine that they have not cited a single case where that doctrine has been adopted, has been used to invalidate a contract. Not
And
one.
then we get back to how the HERE Act plays into all of this,
The
right?
HERE Act declined to play into that. The HERE Act declined to modify the substantive legal standards that define duress under state law. All it did was modify the statute of limitations. It could have created a federal cause of action for these cases. It did not. The standard that governs, that is applied by this court, including in Nazi-era cases, are the common law standards of duress as they ordinarily exist. And under those standards, the allegations they've raised here do not constitute duress as a matter of law. The case should be, the dismissal should be affirmed on all three grounds in which it was granted. Thank you, Your Honor.
Can I ask you, when was the date of that do not tell? Because I don't recall when it said in the complaint.
I believe it was immediately after.
Are we talking about in the 1940s, 1950s?
No, I think it was even earlier, Your Honor.
It was earlier, okay, thank you.
Yeah, I believe so.
Thank you.
I want to start with addressing the last point that my colleague, the counsel raised with regard to duress. Here, economic duress and the third-party duress analysis is completely inapplicable in this context. The HERE Act specifically adopts the U.S. policy as set forth in the Washington Principle and Terezin. And
Can I
this
ask
court-
you please to ignore?
Yes.
Let's assume the HERE Act provides for an affirmative defense, equitable defense of latches. How would you respond to the argument? Let's assume the HERE Act provides for a affirmative defense of latches. It's not barred. How would you respond?
on the duress argument, or?
Whatever you want to say.
Well, I mean, I think if it, on latches, I mean, if it eliminated the defense, we would just be focusing on.
How do you answer the argument that my colleague said from 1974, where there was the Guggenheim letter to
Yeah.
Eric Adler, you have not done anything from 1974 through 2016? I haven't heard an answer that
Right.
can explain it. So maybe I just didn't understand your answer.
Sure. I think as a first point, the argument that knowledge is imputed to the prior generations is largely based on the Bacalar decision, which is a pre-HERE Act case. And
Assume the HERE Act provides for latches. That's my point.
yeah,
What would you say to the question that from 1974 to 2016, there was no due diligence on part of your clients?
HERE Act here requires,
So we're assuming that the HERE Act
Yeah.
does not apply.
Please assume that.
We're
But the HERE
assuming,
Act
for the
doesn't-
sake of argument, we're assuming that the HERE Act does not apply. So we're looking only at latches.
right.
So how would you respond to your friend's argument concerning
See.
latches?
Thank you.
Thank you, Your Honor. Sorry about that. Even putting aside the policy that is incorporated into the HERE Act, the historical reality is that claimants did not have an avenue to bring this kind of claim. And even if you take away the application, the requirements of the HERE Act indicate what should be informing our analysis here, which requires knowledge, not just of the location, but of the possessory interest.
So your clients did absolutely nothing during that period of time after the letter. We can agree to that. Is that, nothing was done?
No, Your Honor.
Do we agree that, so your argument is nothing, I believe you concede that nothing was done during that period, but your argument is that nothing was done because they were unaware that something could be done or that there was an avenue to have the painting returned?
Not that they were unaware, but that there was no avenue for bringing a duress claim in the years after the war. The restitution mechanisms that were earlier referenced did not allow for this kind of claim. And here, while the concept of duress may have existed for many years, this kind of claim has to be evaluated in its context. This is not a run-of-the-mill commercial transaction. This is not mere economic duress, which is what these earlier cases are. Here you have a context that we've been instructed by Congress to treat differently. And New York law has recognized this, that it would be unreasonable to expect victims of Nazi persecution to have pieced together a claim in the years after the war. And it really wasn't until 2009 with the Terezin Declaration that this came to be recognized as something that could be pursued.
So what year did you say, 2000?
2009.
So why didn't
And-
someone do anything from 2009 to 2016?
The HERE Act requires actual knowledge, and that cannot just, they had to have actual knowledge. And as we've alleged in the complaint, which should be accepted at a motion to dismiss, this was not the case until 2016. That is when actual knowledge came to be.
And the letter and statements by Eric in 76 did not constitute any actual knowledge as to the paintings.
Right, so even informing him that it was at the Guggenheim only gives them the location. It does not provide them with actual knowledge of a possessory interest. And we don't know what Adler knew or didn't know, what Adler's son knew or didn't know.
Justice Schumer? Excuse me, Justice Shulman.
I'm sorry. So you say 2016 is the key year, correct?
That's right.
And yet this action started, 7 years later? 2023?
Oh, yes, but it's timely under the, took 20,
I'm not
sorry.
saying it, but my point is we're confronted with a lot of inaction, even under your policy and under the intent of what Congress intended here.
The laches defense, which is an affirmative defense, and
it permitted under the HERE Act.
what's that?
You're allowed to advance the laches defense.
Respectfully,
Zuckerman makes that clear.
well, Zuckerman disregarded binding Supreme Court precedent that analyzed this specific issue of the effect of a congressionally enacted statute.
Well, we also have the fact that there's a consideration to revise the HERE Act or amend the HERE Act to specifically state that laches do not apply. So would that not give us some inkling or some basis to assume that laches does apply?
Respectfully, the proposed legislation of
Yes.
the HERE Act of 2025
Yes.
is a clarification, and it says so in the proposed legislation. It's meant to clarify the current law because courts have frustrated the intent of the existing provision. And it says so expressly it's currently pending, it's
Right.
proposed, but in the proposed language, it says that it is a clarification because of this misinterpretation by the courts.
Justice Shulman, did you have any additional questions?
No, I don't have a question. Thank you.
I know. Did you have any additional?
No, thank you.
Okay. Anyone else, any questions? No. Thank you very much. Thank you all. Liberty Mobility versus Port Authority.
May I proceed, Your Honor?
Yes, please.
Good afternoon. This is a challenge based on a decision in the Acme bus case, which held that when an RFP is used in order to conduct a procurement, it's necessary that the agency does not deviate from the procedures that are set out in the RFP. Here, there were 2 rounds of bidding. In the first round, they complied with the procedures in the RFP. In the second round, they completely disregarded the procedures. With regard to what the procedure was that was required.
So these were RFPs, is that correct?
Yes, ma'am.
So in the RFPs, is there some flexibility when you're dealing with an RFP as opposed to putting it out to bid?
Yes, the flexibility is confined to your ability to use a best value determination rather than simply take the lowest possible bid. There is no flexibility to disregard the procedures you say will apply, which gives rise to the implications of favoritism.
Well, they stated that it was going to, well, I don't know about giving rise to favoritism, but they stated that it was going, there were 2 issues. One was the text score, which apparently was stated that they were going to put more emphasis on the text score as opposed to the pricing. Is that correct?
In terms of our allegations as to, yes, I'm not addressing the test score. This allegation about failure to follow the procedure is
But the
based on
procedure,
fact-
it specifically stated that the technical evaluation was going to weigh more heavily than the pricing. Is that correct?
Yes, but that does not reflect the actual procedure that was promised, Your Honor. That was a small piece which gives a misleading view. The procedure that was promised was in Section 5.1. Article 5, it provided that there would be a fair and uniform bidding process in accordance with the procedure set out in the RFP. The RFP had specific provisions which required the Port Authority to notify both bidders of any amendments to the contract.
Did they not do that?
No, they did not do that, Your Honor.
I thought I saw on the record that they had requested additional information in terms of the,
You're thinking of requests for clarification, which are
Right.
totally unrelated to that. A request for clarification is a request by the Port Authority to one of the bidders to please verify or certify something that's been said in your bid. It is not anything to do with permission to give a second bid. What happened here, the principal argument we're making is that the fair and uniform process that was required by virtue of Section 18 of the RFP, the process terms and conditions, Section 5.1, which says you'll have a fair and uniform process. Section 18 required the Port Authority to notify both bidders whenever there was a revision to the contract. They were supposed to do it by an addendum. That was required. Section 18 required that any proposal reflect the contract terms that were set out in the addendum. In the first round of bidding, the Port Authority had the addenda. Both sides submitted their bids based on that. Each one had one bid. At the end of that bidding, the difference was $81 million better. Our bid was $81 million better. The scoring, which was another factor which was to be considered, was virtually identical in terms of what the technical subcommittee said.
That's not accurate.
Later on.
That's not accurate, counsel. My understanding is while the spread in the initial round was a little closer, Doppelmayr was always ahead of the curve here with every single score, and the margin got progressively wider as we got greater clarification through the technical proposal process.
I don't think we disagree. What I'm saying is...
So your whole focus here is that you were upset that after they already pretty much agreed in terms of the food chain, that Doppelmayr would get it because of, I'm using colloquial expression, would be getting the contract, that they reached out to negotiate the $31 million reduction, and somehow you claim you should have been given that same opportunity, notwithstanding that you were not leading in the technical part, which, as my colleague pointed out, was weighted more than the price proposal.
Actually, the procedure specifically warned the bidders that having the best technical score was no guarantee that you would be chosen. And frankly, the procedure specifically told the bidders, we're going to do a trade-off between the technical scores and the price, and we will do a balancing. The commissioners will make a decision.
See, that's not what I thought, that they said that it was not going to be a balancing, that the technical score was going to weigh more heavily than the pricing.
Actually, Your Honor, Section 5.4, I don't have time to get into it. It does say there will be a, quote, trade-off. There was a balancing. It was necessary to weigh both. The procedure that was promised was fair opportunity to bid. The other side was given the opportunity to put in a second bid on terms that were kept secret from our client. That is not following the process. And with regard to who was better technically or not,
We'll address that on rebuttal. Thank you.
excuse me, Your Honor.
You can address that on rebuttal. Thank you.
Well, thank you, Your Honor.
Thank you, Your Honors. May it please the court, Keith Hemming, Sills, Cummins, and Gross on behalf of the Port Authority.
I was wondering, how do you address your adversary's argument that the contract was supposed to require you to notify the proposers of any changes in contract when it happened, and that did not happen?
Well, that's a good point, Your Honor, and I think that I can address that for you. So first, what I would say is that notification here would be irrelevant. Each party submitted design-build proposals. So in other words, the Port Authority put out what they needed, a solution to solve a problem. Each party came to this process with their own design-build solution. So there's no apples to apples comparison.
I mean, these were very different proposals, it seemed to me.
Absolutely, Your Honor, and they were also contained proprietary information. And with respect to this comment that notification was required, I think that just on that basis alone, notification is irrelevant because we cannot notify one party of how another party's unique design could perhaps be rebutted. They're both proprietary, they're both confidential to the other party, and giving them notice basically would provide them with no benefit whatsoever.
But does it not seem as if you're negotiating one-on-one with one party and not with the other party?
Correct, and we have the right to do so, and I can address that with citations to the record in a couple of parts, Your Honor. So with respect to the right...
At some point, there's a $31 million price reduction on the project, is there not? But how does that come about?
There was a $31 million analysis of the Liberty price proposal during the process of value engineering. So
you let them reduce their price by $31 million, is that it?
Well, what happens, Your Honor, is that each party submits their own unique design-build solution to the problem presented. During that process, the Port Authority, under the RFP, reserves the right to then go back to each proposer, talk about how their design is put together, and then engage in what's referred to as value engineering in order to try to get the best price for the public.
So that was the point. You allowed one party to reduce it by $31 million, but you never negotiated or spoke to the other party about their possibly reducing their price.
Well, Your Honor, I will respectfully submit that that's incorrect because there were no less than 17 opportunities for Liberty to provide clarifications to its price proposal, which would then in turn lead to...
The $31 million price reduction wasn't a clarification. It's something that you came to them with and said, well, why don't you take off this $31 million, isn't it?
No,
Basically,
the
is
31
that
million...
what happened, or is it something else?
I think it's something else, Your Honor. The $31 million delta that we were talking about was based on a review of the proposal documents as submitted by Liberty. Those documents were different and lacking in many respects, including the lack
But is it basically, to put it into simple language, that you're coming to them and saying, get rid of A, B, and C, and that will take $31 million off the job, which makes their bid obviously so much more attractive?
No, Your Honor, because the fact of the matter is that by time that all of the pricing got to the board, that $31 million value engineering portion was not presented to the board. That was taking place during the independent negotiations between the engineers at the project level, where they received the design build from each independent
What is the effect of it for their price to go down by $31 million?
I'm sorry, Your Honor?
Is the effect of it for their price to go down by $31 million?
If there were an award based on technical merits, there could be adjustments to the price based on value engineering process, which was set forth with particularity in the record citation.
So in this process, this is a benefit you gave them, which you didn't give the other party.
Your Honor, I would respectfully submit that that is exactly not the case. And the reason why is because here, this is a design-build project. Both contractors are not bidding against the same set of construction drawings. They're coming up with their own design, their own delivery model, and then their own price. So to compare pricing or technical issues as to one contractor versus a separate contractor is like comparing apples to oranges. It's simply that cannot be done under this particular business model.
So that's, so was I correct in stating that I thought the technical evaluation weighed more than the pricing?
Absolutely, Your Honor. With respect to the best value process, and the record citation there is at page 89, the methodology, best practice, or excuse me, best value, excuse me, is that price does not necessarily matter. Technical aspects take priority, and there can be back and forth with the weight from the Port Authority engineers during the process. And the reason for that, again, is it comes back to this original concept of it being design build. With respect to the air trains at Newark Airport, in the past, there's been a lot of problems with their operation during extreme heat, extreme cold. So when they put out that design basis and information to these major contractors throughout the world, we tell them what problems they need to solve. It is their job then to come up with their own secret sauce in terms of design on how they're going to solve those problems. And then those problems get evaluated independently in conjunction with the best value process. So one contractor can have technical superiority, which is something that takes priority during the definition of the best value process, and another one can have a lower price. And the Port Authority, with respect to its duty to the taxpayers, needs to have something, an AirTran system that runs consistently and that it's on time and that it's important that it's...
So it's clear in my mind, Counsel.
Sure.
In November of 2023, when the executive director was given the ultimate recommendation to go with Doppelmayr, correct? And then in December, but then the award wasn't formally given yet. Then in December, when there was discussions and a request to reduce the price proposal after this intensive evaluation that does what you've just described in terms of best value analysis, when they reduced to $31 million, it's your position that it didn't run afoul of the process because Doppelmayr was already chosen based on the whole RFP process. Is that what you're saying? And therefore they did not need to be given an opportunity, even though the award wasn't formally out there, to reduce their price proposal because technically they weren't in league anymore, correct?
Understood, Your Honor. Short answer to your question, yes, because Doppelmayr, or excuse me, Liberty never led in technical superiority. So their bid at that point in time had no chance. Second part of your question with real specific detail, they rely on slide, which is at document number 1297 in the record, which shows a deduction of 31%. But that is misleading because that was an internal document that was taking place during the value engineering stage prior to it was presented to the actual board. The correct slide, which is 1292, and that is the one where that 31 million is backed out, so they're not prejudiced before the final board's decision as to price, and that's what was submitted to the board. In addition to that, at the record at 1327, Mr. Ralph DePuzzo, who was the chief engineer on the project, went through great detail on explaining how this process actually worked and how Liberty failed to provide technical responses to no less than 17 requests for information as to the adequacy of their design. And that's something that's required. And it's not required just as a customary request. It's actually required under the contract documents.
Thank you. Thank you very much.
Thank you, Your Honor.
Your Honor, I have about 5 or 6 things I want to correct that you have wrong or he said wrong. First, let's talk about the trade-off. Section 5.4 talks about the trade-off. It specifically tells us that simply because you're ahead on technical doesn't mean you're going to get it, and specifically says the Port Authority will not necessarily make an award to the best technical, nor necessarily to the best price. Number 2, the decision was not made to select until the commissioners met. The commissioners' presentation to them, contrary to what was said, is found in a record starting at page 1289. At page 1297, we have the slide, it says best and final. That's what's submitted. The award of the petitioners was in the amount of the best and final bid, the reduced $31 million bid. Third, the procedure that was supposed to be followed, which we say was not followed, which has not emerged very clearly. I'm sorry, I haven't had the time. If you look at section 5.1, it says this will be fair and uniform, and according to the RFP process. 2.16 tells you what the procedures are in the RFP process. 2.16 brings into play section 18 of the process terms and conditions. Section 18 mandates that no bid submitted that does not reflect the actual contract terms as revised. It mandates that you send an addendum. There is no discretion. All of this stuff is Jabberwocky. It's a very simple process. The Acme case says you don't look at who's the better proposer. You don't look at who won.
But I thought that when they had their executive meeting on November 30th, 2023, and they listed when the voting committee got together to reach their final conclusion, and they gave a whole list of reasons that they thought that the design was simpler, was more reliable, and went on and on, a significant list. What was not right about that determination? Why didn't they have the right to ultimately make that determination based on looking at everything at the end?
First off, Your Honor, the voting committee makes no determination as to who's selected as the preferred proposer. The procedure is the commissioners select the preferred proposer.
They made a recommendation.
Excuse me?
They made the
All they do is make a recommendation. The commissioners then have the choice. They did not abdicate their decision-making authority. They just got a recommendation. It was a trade-off. You have to understand, we were compliant. It isn't as though our proposal would not work. That was not the basis. It was a weighing that was done that led to a recommendation. The point here is you cannot defend deviation from the procedures you say you're going to apply, even for the best of reasons, because the goal is to make sure that agencies, public agencies, follow the procedures. And why do they do that? Not to protect me, per se, in this case, me, the bidder. They do it to foster confidence in the public
And so
of the bidders.
specifically, what was the deviation?
Excuse me?
What was the deviation?
Deviation specifically was first, failure to file an addenda saying we have revised the contract. Secondly, there was a failure to give them an opportunity to bid. Third, because the first round of bidding, which was done according to the procedures, was equal opportunity to bid on the same contract. That's the essence of competitive bidding. The second round was we negotiate only with one and persuade them to lower their price. If you ask my colleague here, where does it say they can negotiate during the pre-selection phase? You will get no answer, because there is none. The only time the RFP provides for negotiation is post-selection by the commissioners in section 6.2. That's when they do the value engineering. They don't, and third, they can value engineer in the sense of revising the scope in the pre-selection phase. They can do that. But if they do, they have to issue an addenda under section 18. They have to tell both sides. So it's an equal and level playing field, and then we have the opportunity to bid.
Thank you. Thank you both. Lima v. 1148 Corporation.
Good afternoon, Your Honors. Michael Dombrowski from Perry Bennington for the Appellate, 1148 Corporation. Now, although this case involves an unfortunate accident, it does not involve the invocation of Labor Law 241, subsection 6. Indeed, plaintiff's cosmetic refinishing of a single elevator more particularly regarding to the wood panels, is not part of a larger construction, demolition, or excavation.
But it doesn't have to be. It doesn't have to be because 23-1.4B13 of the Industrial Code Regulations have different categories, and it doesn't require the particular type of process be in conjunction with construction. It lists painting by way of example, and the Jablon case makes clear that you can have a painting project that's not mere maintenance or cosmetic maintenance, which is what your characterization is here. You claim it was error to consider this week-long, extensive refinishing job of the elevators, which requires stripping and lacquering, compressors, not a simple process at all, and characterizes as cosmetic and therefore out of the rubric of the labor law. That's essentially your position.
Right, but the Court of Appeals in Nagel has refined that even further in saying that structural work has to be performed for mere maintenance to fall under Labor Law 241, subsection 6. For example, plaintiff cites to a case, St. v. Syracuse, 2015 in the Court of Appeals, and it was held that in that case, they were constructing large plywood extensions and adding them to a billboard, 59 feet high and using a crane. And it notes and it distincts that St. is completely distinct from cosmetic and decorative modification, which is doomed the plaintiff in Munoz v. DJZ Realty of 2008 Court of Appeals. There, the billboard was just being resurfaced. And that's very similar here. This elevator was not being replaced. They were not putting new wood. They were not putting new material. In that one, they were simply refacing it and giving it a new cosmetic look.
Right, so in Nagel, there was no evidence of any type of construction work. It was, I think the person slipped and fell on oil.
In Nagel, he was doing a 2-year inspection of an elevator.
Right.
And doing safety testing.
But again, as my colleague stated, we're talking about a little bit more in this case. We're talking about painting renovation, taking, again, I don't want to repeat what he said, several days. We're using solvents, we're using sprays, we're sanding. I mean, there's a lot going on. It's not simply painting.
Right, but there's nothing structural going on here. There's no construction, demolition, or excavation
But it doesn't
required.
have to be, I mean, you're reading straight out of perhaps one section, but the law has developed over the years with cases from us and from the Court of Appeals, say it doesn't have to be in conjunction with any kind of big construction project as long as they're construction-related type activities. They were stripping and sanding and working on this wood paneling and putting all kinds of solvents on, like everybody else has said. It's a little bit more, elaborate than what you're saying, and that has been determined to fall within 241(6).
And we stated in Jablon, I guess, I think that was in the 90s, 1998, something of that nature, that painting renovation falls within the statute.
Okay, well, respectively, putting that aside, I will also argue that the Industrial Code 23-1.7G, which was relied upon to grant summary judgment on 241(6), should have not been granted, as at a minimum there's an issue of fact, but we also believe that it was inapplicable. First, regarding an issue of fact, Lima, the worker who was actually using the compressor at the time, testified that he was in the hallway at the time, not the elevator.
Well, I thought he was he was right outside.
In close proximity to the
plastic.
The plastic covering in the elevator.
Right, but he was not inside the elevator, which the court is claiming, which is a confined area in its decision.
I'm sorry, repeat that?
The court in its decision touches specifically upon the elevator, saying that that's a confined area that is deficient of oxygen, not the hallway. In fact, the court specifically
Well, it wasn't like 6 feet away. I mean, it's right, the way I looked at it and saw it, so he went right outside to see if he could do something with this compressor that apparently didn't stop when it was supposed to stop, and there were the plastic hanging because the super said the fumes are bothering the tenant, so we better put some plastic, which didn't sound like a great idea to me, but, I'm not an expert in this. And so how do you say that the elevator was not a confined area, even if at that exact moment it was just right outside, and then it it caused this flash fire.
Sure,
in the
there's a
cab.
few reasons. First, New York courts have never held that an elevator is a confined space with regards to this section of the labor law. Furthermore, there's multiple means of egress with this residential elevator. Not only was the door open and the plastic was only partially covering it, the record shows there's a latch above where there's a manhole cover where someone could get out as an emergency exit, and it's also ventilated for the residents who live in the building. In fact, the day before,
So wait, I'm sorry. So your argument is that because there was the latch, it was not a confined space?
there's multiple means for oxygen to come in there, and not to
But the
mention,
oxygen was not coming in there based upon the solvents, et cetera, that were being used.
we would argue that that was not definitively proven in the record, and not only in this case, with looking not only to the manhole, the latch at the top, the door being open, there's
So
definitive.
again, you're saying because there was a latch and the door was open, there was sufficient oxygen.
I'm saying at a minimum, there's an issue of fact on that, and the court shouldn't have issued.
There's an issue of fact as to whether or not there was sufficient oxygen in the elevator?
Right, because even before the work started,
Why were they using the compressor?
they were just spraying paint, a sealer.
They were using why were they, I thought they were using the compressor because of the odors.
No,
the
Your Honor.
solvents.
So that's a big distinction.
And also the heating. There was
Right,
also
right.
the heating.
So that morning, they were sanding the elevator because they had already applied some coats to make it smooth, and they were just simply using the compressor and a spray bottle to spray the final coat. This had nothing to do with oxygen in the elevator. They were simply painting the elevator by using a sprayer, and it's even been found that the compressor should not have been used in this instance and was not defective, but that's a different point that we can get into. But this has nothing to do with the oxygen where the compressor is.
I thought there was a heavy concentration of air contaminants in the elevator, and that was one of the reasons why they had to use a compressor.
No, that the compressor was simply to spray the paint, Your Honor. It had nothing to do with the oxygen in there. Not to mention.
The rule, I'm sorry, my understanding, you claim this rule or air testing is inapplicable because there was adequate ventilation. That's a claim, right?
Right.
Okay, and on this record, you didn't really challenge any of the information there that, in terms of a confined space, vapors were going out, tenants were complaining, your own workers were complaining about it. So the superintendent here, your client, said, okay, put plastic by there in the office while you're working because the vapors are affecting it, correct? So if the vapors are there, that kind of saturates the environment and impedes the whole oxygen level, which triggers this particular regulation.
Right, Your Honor, but the night before the work started, the elevator is reopened for people within the building to use, right? Then the next morning, all they did was sand. When they started spraying, that's when this occurred. And with regard to this section, there's a duty that it has to be proven that contaminants are already there for us to have to examine it and do testing. Here, all they did was sanding that day, and the night before, it was open to the public and used without incident. So here, we're arguing that any contaminants that were in there were almost essentially integral to the work when they started doing the work. We couldn't have tested before they started working. That would provide a duty that we'd have to continually test the elevator as they're doing the work. And that's not provided for in the case law or the statute.
Thank you.
Thank you.
Good afternoon, Your Honors. In for the plaintiff respondent. I think that I can pass over the
In
fact that,
terms of these industrial code provisions,
sure.
how does the fact that the fire takes place outside of the elevator, right?
No. The flash fire was inside the elevator. As the trial court properly held, it's irrelevant where Mr.
And where were the plaintiff standing?
At the time of the flash fire, he was just outside the elevator trying to turn the compressor off, which he tried to do inside the elevator, and it wouldn't turn off. And
That's Lima, is that correct?
That's Mr. Lima, right. And Bedoya and Flores were holding the plastic over the elevator, also known as a confined space, to prevent the
So the fire
smell from
spreads from
emanating.
that confined space to them standing just outside the,
Yeah.
Lima standing just outside the elevator?
Right, I think it's irrelevant that he was standing just outside when the when it exploded. I mean, that takes Pratt and makes you have to isolate not only the moment of injury, but like a nanosecond of an injury. I mean, he was spraying lacquer inside, couldn't turn the compressor off, which is completely dispositive here, could not turn it off, and I'll get to that in a second, hopefully I have time, could not turn it off, stepped outside the elevator to try to turn it off. At that moment, it exploded as a result of the accumulation of flammable fluids and liquids and solvents and vapors in the proximity to the compressor.
Right, the overheating of the compressor triggered a spark.
The compressor, right, the fire department of New York, it's all over the record. The fire department, I mean, I know OSHA doesn't support 241.6, but it certainly is devastating and actually dovetails in. I'm sorry?
They find duct tape over the
Yes,
squid.
yes, this compressor was profoundly defective in several ways. And Cancosian, it's a very detailed
Well,
affidavit.
didn't they complained about it, and the owner of the company that the plaintiffs worked for, who's not-
Montano.
he said, well, look, we're behind on our work, so I don't care if the compressor isn't working, get this work done.
Correct. And what's really significant about that is at 2 o'clock, several hours before the fire, Lima called him and told him that it was malfunctioning, was overheating.
Right.
And he said, no, use it, cool it with a fan, a little square fan, not an exhaust fan with a pipe. That's nowhere to be found in the record. A little fan, which does nothing, cool it, then reuse it. And what's interesting about that is Montano conceded and testified that in the past, when compressors have malfunctioned in this regard, he takes them out of use and puts them in the shop. Did nothing of the sort here. He told them to continue using it. And Cancosian really explains how the overheating, the repeated overheating and use of a compressor in this regard will elevate the temperature, cause it to turn off, and raise the likelihood of it igniting the vapors in the elevator, which is exactly what happened here. So under one, I'm sorry.
Your colleague seems to say that there was no work being done that day. Can you just clarify? As he said that the elevator was then given to the public at night, and then we came back and action occurred. I think there was a lot more going on, correct?
Sure, it's highly.
Just give the information, please.
Sure. This project was going on since Monday, August 21st.
I'm talking about the day of the fire.
Oh, the day of the fire.
Yes,
Okay, so that morning,
What time did they come in?
I think it was 10 o'clock. And Bedoya testified that he was still sanding, trying to remove the varnish at that hour because it had accumulated. You needed to remove it in order to spray the varnish onto and to spray the sealer and the solvent onto the elevator. So he was removing it. Flores was sanding it. They were still doing that at 11. This incident occurred sometime between 4 and 5. And they brought the compressor in around 2 o'clock. So this work was going on all day. It's irrelevant that it was that the tenants could
So
use
the
it the night
compressor
before.
was spraying the sealant or solvent, whatever they were using, correct?
Correct. They were doing that at 4.
2 hours, from
Yes.
2 to 4.
They were spraying the solvent and the material onto the
For
elevator.
about 2 hours,
For
correct?
hours before the flash fire. Right. So with regard, do I have one more minute? So with regard to 1.7G, it's established that this was a confined space and that these air contaminants were there. The tenants complained. In addition, Montano and the building superintendent knew that tenants complained, and they did nothing to test this.
Well, your friend also states because it's a latch and a door, it's not a confined space.
Well, first of all, as in Cervezio and in Piazza and all the cases with tanks and aeration, you have to be able to get into something to work in it. That doesn't make it not a confined space because you could slide out from the plastic. I mean, in any circumstance where you're working in something, you need to enter it and exit. And this court actually said in Cervezio that an area does not need to be accessible only by a narrow opening in order for it to have a restricted means of egress. So this elevator was shrouded and tightly confined by plastic. That's undisputed. Those two codes, the trial court granted a summary judgment. One other thing I just want to quickly talk about, 1.12-1.7a. It's a pass-through under Nostrum from 1.7g because it's an unventilated confined space. 1.7a, what's really significant about that is Montano's testimony establishes the propriety of summary judgment on this code. Here's why. The code says you cannot take flammable material and use it within 20 feet of an ignitable source of ignition. Montano testified he trains his workers, this is at 810 of the record, to use the compressor a minimum of 5 feet. He also ratified plaintiff's conduct because he said it's actually okay to spray the back of the elevator with the compressor and the elevator door closed. So Montano establishes summary judgment for us under 12-1.7a, which is a pass-through from 1.7g, which is applicable. I would just ask you to affirm the trial court's denial of summary judgment to the defendant on 2.8e, 1.5c3, at 200 in common law negligence, since I don't have time to address it. Thank you so much.
A few follow-up points with that. First and foremost, the OSHA report and the FDNY did not find anything wrong with the compressor. They said the wrong tool was used for this job. It does not say that it was defective in any way, and it's cited the OSHA report in the record stating that.
Where does the duct tape being on the compressor come from?
That's from plaintiff's own expert. That's the only spot, and there's not a single photograph in the record documenting where this came from, this duct tape. It's strictly from plaintiff's expert. The OSHA and FDNY each said that this was not defective and it was the wrong tool used for the job. We represent the landowner in here. This would be a Labor Law 200 issue. There's no industrial code that would be violated by the employer using the wrong tool for the job. And we even argue with regard to Labor Law 200, we were not supervising the means and methods of the work here, nor is there a dangerous condition. So
what about the fact that you told the workers that they had to put up the plastic outside the elevator while they were working?
Right, the super made a suggestion.
So that
residents are complaining. Montano came in and explicitly said, we never do that, and we didn't follow what they said. We're going to do our own protocol. So a simple one-off suggestion here that maybe we can cover the fumes by an uneducated superintendent should not supersede the mean. They're supervising the means and methods, as this court said, a whole week-long job of doing the work there. The landowner here was not running the work, and the compressor was not defective here. This is not an industrial code violation. If anything, it would be with Labor Law 200, where they found an issue of fact, which we're discussing now. So that's why we believe that there's, at a minimum, an issue of fact regarding industrial code violation here. There's evidence from OSHA saying it's not defective, what they're using. They used it improperly, and we're not the ones supervising them. And also going into, I know Pratt's was mentioned before. Pratt's only deals with Labor Law 240 subsection 1, and that does not apply in this case.
Didn't the lower court find a triable issue of fact with respect to Labor Law 200?
It did, but I'm saying that that's more as opposed to 241.6 with the code they found partial summary judgment. It's our opinion that that's the salient argument here, where that should be determined at a trial.
Well, that Labor Law 200 cause of action is supportable, is it not? Or at least that there's an issue of fact? Because there's evidence that the super told them to cover the door?
Well, as noted before, we dispute that there shouldn't be Labor Law 200 claim altogether, because that one mere suggestion that Montano explicitly testified they didn't follow and that wasn't their protocol should not rise to the level of supervising the means and methods of the work. Even the work order here, the sole work order says that the landowner is not supposed to interfere in the work.
But if the super told them to cover the door, wouldn't that fall under means and methods, creating an issue of fact?
It's possible, and they told him no.
Thank you.
Thank you.
McGregor v. Manhattan Nursing Home.
Thank you, Your Honors. May it please the court, John Grill, on behalf of Ms. McGregor, the plaintiff appellant. Not having an adversary here, normally I would just leave and submit. The reason I'm actually going forward with argument, and I'll try to be brief, is because a decision dismissing a case should be based on actual facts. It shouldn't be based on something that's false. And the court's decision in this case was based partially on a false statement that doesn't appear anywhere in the record. the court, in its decision from the bench, stated that part of the, let me back up. This is a case involving a slip and fall where the issue is a
Right,
special.
so the issue is whether she was a special employee or was she not a special employee, and if she was a special employee, then it'd be barred by workers' comp.
Yes, that's the issue.
So what was the false statement, or?
The false statement was that the defense counsel stated at page 29 of the deposition of Mr. Jorge and record 235 that he stated that the defendant assigned the security guards to their security posts, and that fact is nowhere stated in the deposition or anywhere else in the record. And then the court then adopted that.
Didn't the plaintiff testify that Mr. Jorge was her direct supervisor? I mean, we know she was employed by an outside security company, but she'd been working at this particular location, I thought, for about 5 years.
That's true. She was working at that location for about 5
So
years.
she had a direct supervisor of Mr. Jorge who would, she didn't call her security place every day and say, what should I do with at defendant's place of business, did she?
I'll get to those facts, but the major point about that is that, first of all, that was a leading question by counsel. Oh, is Mr. Jorge your direct supervisor? And then the plaintiff right away said, oh, yes, except the record doesn't show what that means at all, but I'll get to that point.
Okay, so even if we'll put that aside. We won't consider, that will not be considered. She testified, again, that she had been at the facility for 5 years on a full-time basis. She stated that she received on-site training from the defendants.
No.
Yes, that's what she said in her deposition.
No,
and she said that from the defendant supervisor was on site. She reported to defendant supervisor on site and communicated directly with the supervisor on site.
The facts in the case are that Mr. Jorge himself stated that Ms. McGregor was the supervisor of the other security guards, and he himself stated that her manager was off-site. The facts showing that there's no direction or control by the defendant in this case are that, A, plaintiff received her uniform from City Security. She submitted her job application to City Security, her employer. City Security decided where she went. She had been at another location for a month. Her uniform and badge say City Security. Plaintiff renewed her own security license yearly. She had on-site training by her employer, City Security, over 3 days at the location, not by the defendant, by her.
5 years prior, or 4.5 years prior, right?
But that's,
so for the 5 years, was there anything in the record that during that 5-year period of time, on a day-to-day basis, she would contact City Security in terms of her day-to-day duties or day-to-day operations?
Yes, there is.
What page? Because I didn't see anything. Where does she state that? Or where is it in the record that she reported to them or had anything to do with them on a day-to-day basis during that 5-year period of time?
Plaintiff's affidavit states.
Oh, but that was an affidavit tailored
right.
to contradict her original testimony.
No, that was not. Respectfully, Your Honor, her original testimony was in response to a leading question that stated, wasn't Mr. Jorge your direct supervisor? She said yes, and then there are no facts that show that to be the case. In fact, Mr. Jorge himself states her manager was off-site. He could not discipline these security guards. He did not.
You brought up training. Didn't she also get training by defendant?
No.
When she starts?
No.
She's issued a radio by them?
She got the radio from them.
But she said she was trained by them as well.
For 3 days.
I don't know.
Yes.
I don't think so, Your Honor.
Okay. Well, you know what? We'll look again.
Also,
so thank you so much. Have a great day. People v. Jerry Marte. Yes.
Good afternoon. I may please the court. Nicholas Halleck, Hallwell, Schuster, and Goldberg for appellant Jerry Marte. Officers McCormick and Martinucci did not have reasonable suspicion at the time they ordered Mr. Marte to stop. There is a crucial distinction in the case law between a hand on a waistband, which does not give rise to reasonable suspicion, and a hand holding an object to the waistband, which does. The prosecution claims that Officer Martinucci, and only Officer Martinucci...
This isn't based just on holding the hand by the waistband, right? I mean, there's some other facts here too, are there not?
There are other facts. I would say...
How do they come to be staking out? How did the police come to respond to that location?
Right. The police received, 4 or 5 days before they went to that location, they received an extremely vague tip that there was a gun on a person, on an object.
Vague. It says that the gun would be located near or under a milk crate, a garbage pail.
Right. That's the three different places.
Specific.
And
three different
aren't
places.
they also told that this happens after the police go off duty, go off, the anti-crime unit reports back to the precinct?
Yes, that is part of the tip.
They're given a time. They're given a time, and they
And a
come
location.
after that time. The police now are told that you can expect to find a gun there at that time, and that's the time when they show up, right?
And the location also.
Yes, it's 4 or 5
So they
days
give
later.
time, they say sometime after 1, because that's when anti-crime normally goes off. They give the location, West 174th and Audubon, and they also state that it's going to be near or under a milk crate or a garbage pail, or it could be on someone. in that
Right.
location.
The tip identifies 3 different places it might be. This is not the kind of specific tip that you see in most other cases that say there's a gun on a person who's wearing something and is a particular...
But all on that corner. We're concentrated on the corner of West 174th and Audubon.
It did identify that location, yes.
And there's a group of people, the others don't take off, whereas the defendant has his hand in his waist area and takes off.
The defendant walks away from the officer
After being told, in some fashion, maybe that's not clear exactly how, but after the police indicate that he should stop.
Yes, he did run from the police after they indicated he could stop, and we're identifying the initial shouts at him by 2 officers to stop as the level 3 stop. So anything he did after that can't be taken into account when determining whether they had reasonable suspicion. And I'll point to People versus Sierra, a case from the Court of Appeals that explains that a hand walking away from officers with a hand on his waistband does not give rise to any indication of criminality. So we think there's a couple of facts here for sure, but none of the facts, they all have serious problems with them. And so combining a group, this extremely vague, stale tip with facts that did not indicate criminality can't add up to a reasonable suspicion of criminality on Mr. Marte's part. Turning to the abandonment issue, the government claims that Mr. Marte abandoned the firearm. I would point this court to People versus Bilal, its case from 2019, that held that when somebody is fleeing the police after an illegal stop and drops contraband, that does not constitute voluntary abandonment, and then that should be suppressed because of the initial illegal stop. And I also wanted to talk about the sentencing issue. Mr. Marte received a 9-year sentence for firearm possession. We believe that sentence should be reduced to 7 years. We think it's very important that this...
Well, he was the second violent pred, right?
Yes, and that's taken into account as part
And
of
I think
the statutory range.
wasn't his prior for a possession as well? Yeah, 2016 is also criminal possession of a weapon?
Yes, he had previously been convicted of criminal possession, which was a felony, and that's taken into account in calculating his statutory range.
And that was in 2016, and this occurred in, 3 years later.
That occurred in February 2015 when he was 17, and this was July 2019. So, yeah, it was, but I would also point, I think it's important to look at the full picture. Between July 2019...
How old is the defendant at the time of this incident?
He was 22.
22?
Yeah, that's right. Between July 2019, when he was 22, and July 2022, when he was 25, he was out of prison between the arrest and conviction of this case, did not commit any new crimes, had 2 children in that period. We think that shows his ability to mature and rehabilitation. So we ask only for reduction to 7 years, which is still a very substantial sentence for simple firearm possession. where he did not point the gun at anyone, did not use the firearm. If Your Honors have no further questions, we'll rest under briefs.
You have time on rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. Samuel Goldfein on behalf of the people. First, to order a defendant to stop, the one officer said, "Police stop." The other one said, "Hey, come back here." The officers only required level 2 suspicion. They had level 2.
Well, what was that? I mean, what was, he's allegedly shooting dice with a group of individuals. Why should he, you know, why would they even have the basis to say, you know, stop or anything of that nature?
Well, they see a crime happening in front of them.
sorry?
Apart from the tip, they see a crime happening in front of them. They're not sure whether or not defendant is involved. They can ask him pointed questions to ascertain if he was involved or others were involved, if he was merely just watching the dice game. The other thing that happens at that point is that before the officers even close...
What was the crime? Was it gambling?
That's what they saw. They saw people throwing dice and exchanging money on the public street corner.
And that would be a crime?
I believe so. I cite the statute in the...
Yeah, it is, but I mean, we don't know, as you said, you don't know whether he's participating in the dice game or whether he's a spectator.
Absolutely, Your Honor.
That was my point.
No, and absolutely, Your Honor. We don't know if he was a participant or merely a spectator, and that's what level 2 exists for. You can go and ask...
So they would have the right at that point in time to discern whether he was a spectator or whether he was a participant?
But before they've even gotten out of the car, yes, they could approach the dice game and question those individuals. Who's involved? What's going on here? They could ask pointed questions of that nature. But more importantly, before they even close the car door, Martinucci notices that defendant is backing away from the police. He's got his hand on his waistband, and he can tell that there's an object there that's dense and heavy, which is a telltale sign of a gun. Right? The testimony, there's an argument in the reply brief that's not the order of the events, but the prosecutor asked a clarifying question. Could you tell anything about the object that was in his waistband? And again, this is at the time as you were getting out of the car is the prior question. And he says, I couldn't see the object in his waistband, but I could tell that it was dense and that he was trying to stabilize something there. They order him to stop at that point. Defendant turns and runs, and while he runs, he maintains his hand on his waistband, which again, we see the cops running with their guns. They do the same thing. They run with their hands on their waistband. It's reasonable suspicion at that point. They only need that reasonable suspicion when they start pursuing defendant. The chase unquestionably requires reasonable suspicion, but they have it at that moment. As far as the abandonment is concerned, the police encounter was appropriate from its inception, so when he tossed the gun and they recovered it lawfully afterward is entirely fine. This court has found calculated abandonment under circumstances like this, where a defendant holds onto the object for a brief period of time, but a period of time nonetheless. It's not like a spontaneous, he drops the gun. And then the manner in which he discards the gun is designed to evade capture by throwing it into the trash. On the excessive sentence point, just very briefly, defendant was only 22 years old at the time of this crime, but he had a fairly lengthy criminal history. He was convicted of weapon possession just 1 block north.
Were there other crimes that this was supposed to take care of too? Was there some type of gang assault that the court also considered in the sentencing?
Yes, Your Honor. So between when defendant was convicted in this case and sentenced in this case, he pled guilty. The prosecution allowed him to plead down from his role in a gang assault and robbery where he held a box cutter to a man's neck. Defendant's accomplices took his property, and then when the man tried to flee, defendant...
And when did that happen? After this?
So that crime happened first. It happened, I think, 3 months before the crime in this case. I'm not positive about that date. But he pled guilty in the middle. And with the understanding that because he was going to be a second violent felony offender facing his second violent felony conviction...
He pled guilty on that in the middle of this.
In between, after he was convicted in this case and before he was sentenced in this case, he pled guilty in that case. To misdemeanor
What did he
menacing.
plead to on that case?
Misdemeanor menacing, Your Honor. The prosecutor let him plead down with the understanding that the sentence here would cover both of those incidents. Apart from that statement, Your Honor, the fact that defendant has committed...
In fact, in that case was a robbery in which he held a box cutter, you said?
Correct, Your Honor. To the victim's neck, his accomplices took the victim's property, and then when the victim fled, defendant and his accomplices assaulted the victim. He was struck and stabbed. Apart just from that allegation, the fact that the prosecutor asked for it to be considered part of the sentence, defendant made no objection at the time. There was some argument on the reply brief that defendant never agreed to this. That's the kind of allegation that you think would make somebody say something. Certainly, defense counsel.
So in the CPW2 as a second violent pred, what would the max be?
The max, I believe, was 15. The minimum was 7.
So the minimum was 7, the max was 15, and
people asked for 10. He got 9. And again, the fact that he's not just a second violent felony offender. He's not a persistent because he was convicted of the second after the sentence. But he's more than just a.
Is there anything in the record as to any pretrial offer?
I'm not aware of a pretrial offer, Your Honor.
Thank you.
If there are no further questions, then there's an evidentiary point. I'll rest on my brief and ask that you affirm.
Thank you.
Thank you.
Thank you. So 3 quick points on rebuttal. First is to point about whether the officers required reasonable suspicion because it was a level 3 stop. I would point, Your Honors, to People versus Bora that explained.
Yeah, Bora is just a little, I mean, it is distinguishable from the facts here, don't you think, in terms of exactly, I mean, there was no real predicate in Bora was really a level 3, right? We're just talking about perhaps a level 1?
The facts in Bora, I think, were only a level 2. I think the officers were about 15 to 20 feet away from the person, and only one of them had ordered him to stop in that case. So certainly we don't think this is identical to the facts in Bora. I think it's actually stronger. But Bora identifies a number of factors that, when considered alongside a verbal command, can constitute a level 3 stop, and many of those factors are present here. So there were multiple orders to stop by multiple officers. There were 3 officers approaching Mr. Marte, and the police car pulled directly in front of him. So we actually think this was a level 3 stop. We certainly agree with my friend on the other side that the officers could have asked him pointed questions, but the only things that were ever said to him were police stop and hey, come back here, which are not questions. Those are not the questions of a level 2 inquiry.
How could they question him if he ran?
Maybe they couldn't have questioned him if he ran, but in order to stop him and order him to stop, they would still have required a level 3 stop. These weren't questions. Yeah, thank you. Then to address quickly the colloquy at the suppression hearing transcript, it's important to note Officer Martinucci said twice that he saw Mr. Marte with his hand on his waistband. He said that once and again. Then it is the prosecutor who brings in the idea of an object. And while Officer Martinucci agrees that he suspected an object, he's very careful after that, and he has already testified at this point that he ordered Mr. Marte to stop and Mr. Marte ran. He's very careful not to say that he saw the object or even suspected the object before Mr. Marte started to run after the orders. So we actually don't think it's a reasonable reading of the transcript to read Officer Martinucci testify. And then one more point, if you wouldn't mind, about the plea bargain. Mr. Marte was sentenced he pleaded guilty to the misdemeanor for what the prosecution says is a gang assault. He was sentenced for that already in October 2022, which was before he was sentenced in this case in February 2023. He was sentenced to time served in that, so he'd already been sentenced. So we actually don't, there's nothing in the record other than the prosecutor's own statements that this sentence in this case was supposed to be some sort of global disposition. He went to trial in this case. There was no plea bargain. And the prosecutor, of course, mentioned his prior convictions, but there's nothing.
It seems rather obvious that the sentence is not a matter of global disposition, but that's an additional previous criminal event.
Of course, absolutely.
We're not dealing with the second violent felony offender that has this one prior gun charge. We're dealing with the second violent felony offender who has a prior gun charge and also had a misdemeanor assault.
It's a misdemeanor menacing charge he pleaded to.
Which seems to have emanated from a rather serious incident. I mean, it's not just a matter of a charge, I mean, but it's, it sort of undermines, it seems to me, the case for saying that the defendant should get minimum time on this conviction.
I understand that. I point out that the facts about what happened in that case are only in the record insofar as they were represented by the prosecutor, and they were not facts that were he was ever convicted of or pleaded to. He pleaded to a menacing charge and was sentenced to time served. So I'm merely quibbling with my friend's argument that the sentence in this case was really for both crimes.
Well, it's academic. It would have been subsumed anyhow. But thank you both, and thank you and your firm you did this pro bono?
Yes.
For your pro bono defense in this case. Thank you so much.
Thank you.
Suarez v. City of New York.
Good afternoon, Your Honors. Mark Miner, Zalmas, Sherman, and Miner for the plaintiff appellants. This is a case as whether or not the city had prior written notice of a condition.
Yes, of the sidewalk or lack thereof. So in your papers, you argue that there's some responsibility on the city to provide a sidewalk?
There's a responsibility of the city to provide a safe premises on the property they own, including a sidewalk, or in cases where, as in this block, there's sidewalk and then there's missing flags in between the sidewalk. So the plaintiff starts off on the sidewalk, then she hits a grass area, then the sidewalk resumes. The prior written notice they have is exactly that, no sidewalk, which the city admits they have. There's no question in the record that they have a Big Apple map that says no sidewalk at the specific location that plaintiff fell.
Well, that's a fact. That's not an obligation. In other words, you clearly don't have prior written notice of the raised edge that your client, I'm not going to get caught up with the whole edge. Let's accept for the fact that it's the raised edge as part of the driveway of that property, that her foot got caught and she fell. So you make an argument that was a trip hazard, and now there's nothing in the record that there was prior written notice of that particular defect, correct?
The only notice is that there's no sidewalk. And
Okay.
my position is that but for the fact that the sidewalk was missing.
But that's not the defect which causes the fall. It's the cement at the adjacent property, which that there isn't prior written notice of. The Big Apple map doesn't say, hey, you've got a cement ledge there which needs to be dealt with.
It is our position that but for the missing sidewalk, you wouldn't have a ledge. And there's many cases, and I cite several cases, which says when the city has notice of a condition at the exact location where the plaintiff fell, it raises a question of
But
fact.
the question is what the condition they had notice of is.
Right, and there's many cases where, the notice on the Big Apple
Seems like
map
there's no question that they didn't have notice of the defect which actually caused the fall. And your position is, well, they could have inferred that defect from what they did know.
Well, my position is that the missing sidewalk flag was what they had notice of and was what caused.
No, that's not accurate. Your client, based on this record, and there's really no dispute, she acknowledges that she tripped over that broken edge of the driveway portion of the property that you're calling a sidewalk. Just bear with me for a moment. Then you raised the theory that, well, when they removed the tree 2.5 years before this accident, somehow that was creating that particular defect of the raised edge. Okay, that's somewhat attenuated. And then we acknowledge that between the two properties that she walked from one to the next adjacent property where she tripped, that whole expanse area is all grass, where the tree was part of that at one time. Somehow, there's no sidewalk. But that's not what proximately caused her injury. And you know that in order to be able to keep the city in the case, they need prior written notice of the specific proximate cause of her injury. There wasn't a missing sidewalk walking on the grass because she didn't slip on the grass. She tripped on the edge of the adjacent property's driveway portion. So then how can we, according to you, reverse the lower decision?
Again, Your Honor, I'd refer to the several cases I have in my papers, including the Castro case, 243 East versus 283 East 138th Street, a case which you decided on this panel that said basically very similar to our case. Case coming out of the Bronx, plaintiff was injured when he tripped and fell in a hole between a tree well and the sidewalk. According to the plaintiff, the dirt in the tree well was lower than the sidewalk. And the court said the size, shape, configuration, location of the Big Apple map's line marking in the same area of the sunken tree well, which indicates a raised or uneven portion of the sidewalk, raises an issue of fact. So there you had the plaintiff stripped in a hole between a tree well and the sidewalk. The marking was a raise. And the court said, it's the same location. It puts them on notice. And there's several cases.
Your claim was that she tripped in a hole in the grass. Now you're stating that the proximate cause of her fall was a missing sidewalk that gave rise to a raised driveway edge. It's totally different.
All right, if we go back to the notice of claim
Right?
I have the notice of claim right here.
It certainly states.
That's not what you stated. And that's really not what she testified to. But I have your notice of claim, and that's not what you stated in your notice of claim.
It states that the missing sidewalk in the notice of claim.
You said it was a hole.
I have the notice of claim right here.
But again, is there any notice to the city as to the sidewalk?
The only notice to the city is that there's no sidewalk. I don't dispute that, and we state in our notice of claim that
one or more sidewalk flags was missing, and that a section of the sidewalk was never built.
correct. So that's in the notice of claim. In her
To become and remain in an uneven, broken, unlevel, depressed, raised, jagged, missing, and/or defective condition, in that there was a grass and dirt path in which the sidewalk should be.
Exactly. That's our claim. And her testimony is, I know she said her foot hit the edge of the sidewalk. It was like a hole. I mean, she's figuratively speaking, and there's pictures of the foot at the edge. You know, that's our claim. That there's no sidewalk, they have notice of that, and that's in our notice of claim. But for the fact that the sidewalk flags were missing, there would not be an edge for her to trip over.
Thank you.
And that puts them on notice.
Good afternoon, and may it please the court. Chloe Moon on behalf of the city. I think, as the colloquy made clear, the best way to understand this case is that plaintiff tripped and fell on the jagged edge of a cement driveway that was a special use by the Fields defendants. She didn't fall as a result of a negligently maintained sidewalk, and the city did not have notice of any defective condition, like a hole.
The argument is that there should have been a sidewalk there.
Was that your obligation under any?
We don't believe so, Your Honor. I think if you read Administrative Code 19152, that's an obligation on the property owner, and then this court's case in Herrera that says there's no affirmative obligation to create that kind of sidewalk here. So we think if you read the statutes together, it's very clear that the city doesn't have an obligation to install a sidewalk here on this grassy patch, which I think, just looking at the record, the best indication in the records from DOT and Parks is that it's a planting space. That's what this grassy area is. So we think reading all of those statutes together, there's no obligation, no affirmative obligation on the city to install a sidewalk here, and there's no notice of a negligent defective condition here. So as the colloquy, I think, made clear, there's no notice of a hole, there's no notice of the jagged defect, nothing on the Big Apple map shows that. And we concede it says no sidewalk there, but we just don't think that's an affirmative duty that we have. So unless the court has any other further questions, we ask it to affirm.
Thank you.
Thank you so much.
Yeah, I would just restate that there's no question there was a hazardous condition here. And the hazardous condition was noted on the Big Apple map. It was noted on the Park Department's inspection reports. They would have not made these notifications if it wasn't a problem. So while they may not have had an affirmative duty to put a sidewalk there in the first place or put a sidewalk anywhere, they have an affirmative duty to, again, have a safe premises, whether it's in a park, a sidewalk, or anyone else. And once they're on notice of a defective condition, it could be a hole in a playground, they have to repair it or suffer the consequences. And here they were on notice of the hazardous condition, the lack of sidewalk. Plaintiff tripped because of the lack of sidewalk. The case should at least go to the jury on a question of fact as to whether or not the city had notice, priority notice. Thank you.
Thank you. Thank you both. Ancart v. Cresbow.
May it please the court?
Please.
Ron Mukherjee for the appellant and defendant below Million Cresbow. Viewing all the facts and the evidence in light most favorable to the non-moving party, the party not moving for summary judgment, my client, Mr. Cresbow, worked for Mr. Ancart for several years, for about 5 years, was friends with him for many years more than that, and his only compensation for his 5 years of services, by far his main compensation was having American Express bills paid.
Right, I know you're claiming that the monies owed or the monies taken were for unpaid salary because he was able to make, that was for unpaid salary, right?
Effectively, though, it was partly that was the deal
So
between.
what about the agreement where he agrees to pay back these monies immediately?
So, right, so the so-called repayment agreement, again, viewed in the light most favorable to my client as the non-moving party, this was an agreement that was presented to him during a very frightening time when his relationship with his friend and business partner had completely broken down. He's facing violent threats to himself, threats to his family.
Parties confirmed that they have reviewed and considered this agreement and have consulted with their attorneys regarding the terms and effects thereof.
That's correct, Your Honor. The repayment agreement says that, and that's only one of several statements that are false
So the
contained within that
thing is,
agreement.
you argue at some point about a repudiation, but wouldn't you have had to have done that way before you did? I mean, you waited over a year till the plaintiff moved for summary judgment in lieu of complaint, and then put in an opposition and say, oh, we repudiate this agreement. Isn't that too late?
So the same conditions that created the dress in the first place still pertained after he signed the agreement.
The whole year and plus?
Mr. Cresbow believed, whether wisely or not, he believed Mr. Uncart's promise that he wanted this to hold over him, but he didn't plan to enforce it, and the threats of violence that he was facing. Those threats didn't necessarily
I'm sorry, he believed that it would not be enforced against him? Where is it state that in the record?
He does state that in his affirmation, or somewhere in the probably 44, 45 range in terms of record.
Counsel, on page 79 of the record, which is a series of emails from, I apologize, Luke Sarian, on behalf of the plaintiff, I guess, to your client, and they're discussing the terms of the agreement, they're discussing the disparagement clause that your client would have liked to change. And what I read here, and particularly on March 4th, 2022, can we have a non-disparagement clause which applies to both parties, not only me? If not, I understand. Send me the link today. I'm going to sign what you want because I want to make reparations for what was done under your conditions. I mean, no one had a gun to his head. No one forced him to write that email. And as was pointed out, he waited a whole year to suddenly make a claim of duress. Parenthetically, the earlier email suggested they gave him a 1-year grace period. I guess when he knew he had to pay, suddenly now there's this concern that a gun was put to his head. So given that the actual repayment agreement is clear and unambiguous, has set terms, certain date, and normally fits squarely within the 3213 protocol, where's the issue of fact?
Because, Your Honor, this is just one of several cases in which several instances in which the statements in the clear and unambiguous repayment agreement is actually false. I don't know who the wolf is or this Loop Sarion depicted in this document, but that doesn't it's certainly probative document, but that doesn't repudiate the fact that he was under threat at the time or under duress. This is something that creates an issue of fact. It doesn't eliminate issues of fact. Where is his counsel? Respondent can't even point out who was my client's counsel because he never had any. They just say, oh, the repayment agreement says that he had counsel. It does. The repayment agreement also says that the payments were unknown to Mr. Ancart from 2019 all the way to 2022, but we have documents showing that he's discussing those with Mr. Ancart's accountants in 2021. In 2020.
You have time on rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. This case is about as straightforward as it gets. The defendant, appellant, stole somewhere north of $600,000 from my client when confronted. He capitulated even in the agreement itself. He admits he has converted and stolen this money. My client was kind enough to allow him some time and payment plan to to pay it back after that time has expired, then all of a sudden it's duress, it's unconscionable somehow. I don't know how it's unconscionable to pay back money you stole from somebody. There is no evidence of duress. In fact, the record shows that there actually was a civil exchange, and he was sorry, and I don't know how.
What about that email between the defendant and Sarion, in which they were arranging for defendant to sign the agreement?
You're saying that there was duress in that?
No, that shows that there wasn't duress.
Exactly, that's what I was referring to, that there is no duress. And many times, this is just, I mean, you don't have to have an attorney physically involved in the exchange for them to review it. I review documents all the time for my clients. You know, he's a very sophisticated guy. Both parties were very sophisticated.
That email is with the third party.
Right, no, I understand that.
It's not like he's got to say to the plaintiff because he's afraid of being attacked.
Exactly. So, is there anything else, Your Honors, you'd like to rest on the record?
Thank you very much.
Briefly, I'd just like to say that there's no question that some of this evidence is probative. Also, the boilerplate language in the contract is probative. It's relevant. It can't be dispositive in the face of other evidence. We have here.
Does that not go also to your argument, weigh against your argument that it's unconscionable because it is a boilerplate contract?
Well, so a boilerplate contract in some of its terms, like for example, there was no duress. It states that both sides had counsel and the opportunity to review. That language is standard to include in a contract. But what about the admission of theft? I mean, as practicing attorneys, we've all had clients who don't have a leg to stand on, and you have to cough it up, but you would never sign something like that.
How do you explain an email to a third party in which she indicates a willingness to sign this agreement?
Well, that document is probative, and I'll readily admit that that's favorable to Mr. Onkart, but that does not conclusively prove that he was not under separate threat and not thinking clearly, which he says in his affidavit.
Is it enough for you to just conclusively state, oh, I was afraid he was going to shoot me or something like that?
Is it conclusory? There would be no documentary evidence expected if there's something like that. So,
I mean, in the face of documentary evidence indicating his willingness to sign this agreement, not made to the plaintiff, but to a third party.
yes, Your Honor, but that, like I said, that is probative, but does not conclusively show that he wasn't afraid, whether rational or not. And that's one of the reasons why summary judgment is inappropriate, because Mr. Cresbow's state of mind, whether he was under duress or not, is a very important factor in whether the contract is enforceable. If there are no further questions.
Thank you. Thank you both.
Thank you.
Owen v. Johnson.
Good afternoon, Your Honors. May it please the court. Robert Michaels. I appear as the appellant. The lower court erred in denying the appellant's request for a change of custody and for the appointment of a parent coordinator.
So this is an unusual case, it seems, that the parties, not terribly long after the divorce was started, negotiated a 73-page stipulation of settlement that dealt with pretty much everything, and had attorneys on both sides, and that was the end. Very shortly thereafterwards, you come back, your client come back, and all of a sudden want to set aside an awful lot of those things because of changed circumstances. I mean, what changed so fast after you spent all this time negotiating a lengthy, comprehensive stipulation of settlement in this case?
Justice Kapnick, you're correct that they negotiated a lengthy agreement, including custody provisions, and that was in September of 2001.
Right, 2021, right?
Yes, 2021. And 14 months later, one of the cornerstones of the agreement concerning custody was that they had a parent coordinator. At that time, it was supposed to be just Dr. Kuchek. Dr. Kuchek couldn't serve, and they spent the next 14 months, and the appellant tried to get a a parent coordinator who was sorely needed in order
Why
to.
is it that he could not serve?
Because
Was that because of him or because of the parties?
Unfortunately, Justice Weber, her husband was very ill and eventually passed away, and she had to attend to him. And
So then didn't they go to
Right, then there was some-
Heimowitz? Didn't,
they first went to Dr. Weiss, and the respondent interfered.
So that was the one I think I was referring to, where there was an issue in terms of perhaps conflicts between one of the parties and the parent card.
Right. So the respondent refused to sign a retainer with Dr. Weiss, tried to negotiate out provisions that were consistent with the agreement that the parties had signed. During this same time, it wasn't just the PC, which, by the way, there's case law that says that the failure to be able to agree on a parent coordinator is sufficient change of circumstance to require a modification. The respondent claims we have been able to decide everything, yet at the very beginning, he refused to agree to a parent coordinator he challenged the right of the parent coordinator to assist the parties. The AFC, who was appointed to represent the children, even pointed out on the record in October of 2023 that his conduct was interfering with the ability of the parties to make joint decisions because he was challenging the parent coordinator. So, Justice Kapnick...
Wasn't one of the things that he said was the parent coordinator that you suggested was very, very expensive, and they didn't want to, I think that might have been former Judge Pearl.
Yes.
I mean, there's a lot, I mean, not tons of parent coordinator out there, but there are people out there. I mean, why were they having all this trouble?
Well, that jumps ahead to motion sequence 4, Justice Kapnick.
Well,
we are starting
we don't give you that
at your
much
initial
time.
question, why were the parties back in court? The reason for that was that the respondent would not agree to a parent coordinator that would perform the functions that were intended under and were required and instrumental to implementing their joint custodial and agreement. In fact, Dr. Heimowitz, who presented a retainer, he also objected to, and that led to the first application. And that was motion sequence 2, and that was 14 months later. When we finally resolved that, and he was forced to sign that Dr. Heimowitz retainer, in 3 months later, his conduct forced Dr. Heimowitz to send a letter of resignation, which is in the record, that identifies all of the problems that he was creating, his refusal to cooperate, his refusal to co-parent, and recommended that he get parent education classes. One of the most important aspects of the decision-making that had to be made within that 14-month period was that both children were suffering and needed therapists. The father refused to agree to a therapist, recommended by Dr. Kuchik, in fact, and
Didn't they eventually get therapists?
they eventually got it on the condition that the mother, appellant, had to make that she would restrict or limit the father's obligation to $250 a month. And on that condition, he agreed that Dr. Hasser could treat the younger daughter, who was at that time 5 years old. And then by the time that Dr. Heimowitz got involved, the older child, the boy, Emlyn, was suffering from self-harm, night terrors, and it was recommended that he have a therapist, and the father not only objected and interfered with that, but he had his 7-year-old son write a letter to his mom saying, I do not need to see a therapist, I am not having nightmares, I am fine, and I don't need a therapist. Dr. Heimowitz got involved. He attacked Dr. Heimowitz and said he had no right to make a recommendation.
Thank you. Your time of rebuttal.
Thank you. May it please the court, I'm Burton Whitman from Mantel McDonough Riso, attorneys for the respondent father, Professor Jonathan Owen. everything that you just heard had to do with motion sequence 2 and motion sequence 3 from 2022 and 2023. Justice Hoffman denied those motions in April of 2024. In May of 2024, 30 days after Justice Hoffman's denial, the appellant comes and files an emergency motion seeking to strip his custodial rights and reduce his access time, including seeking to separate the children. Justice Perlman denied that motion in November of 2024. In December of 2024, they filed another emergency motion, again seeking to reduce the respondent's access time and strip him of his custodial rights. So to answer your question, Justice Capedick, as to what changed, nothing changed. There is not one single actual major decision, capital M and capital D, as defined in their agreement, that was not jointly made throughout this process. Maybe not always as timely as they wanted, maybe not always as straightforward. They're former spouses, but every decision for these children has been jointly made. There is not one that has been identified that was not jointly made that they had to go to court.
Is there a parent coordinator currently in place?
No.
And so there really hasn't been because Heimowitz apparently resigned after a couple months. So is that part of the issue, that there's no parent coordinator here?
There is no parent coordinator. Justice Perlman has twice, motion sequence 4 and 5, said, follow your agreement. There's a protocol for the selection of a parent coordinator. Each side's allowed to veto a parent coordinator. There's a protocol as to how you get to the next one, but the parent coordinator is only a tiebreaker mechanism if there's a continued dispute on resolving only
like a major decision.
A major decision.
I think
and
there's a
detailed
dispute about
protocol about notification of a major decision, responding to a major decision, and then only if at that point, then you go to the parent coordinator. Because there's also routine decisions, diet, wearing apparel, that's separate. That's not subject to the parent coordinator dispute resolution mechanism. So Justice Perlman has indicated again and again, go follow your agreement. The appellant has refused. So going also to what's changed, Justice Perlman said appellants failed to present any evidence of that the parties are less capable of making joint decisions.
Well, that's because the mother moved for sole custody, right?
Correct, and they've made their
joint
joint
decisions. And that was denied.
Yes, they have made their joint decisions. Justice Perlman has twice denied appellate, saying she has failed to present any evidence that respondent is less fit as a parent. He's totally fit as a parent. On the spectrum of parenting, he's fully involved with these children's lives. There are hundreds of pictures in the records that show this day in and day out. They're not Kodak snaps. They're real pictures throughout the
Well, I
jail
think
life.
there was issues as to the medication to the daughter, I believe.
Sure.
The Flonase and another medication to the daughter taking on the camping trip when there was a poor air quality, excessive bites from bugs. There was that issue as well.
So the air quality, that was from 2023.
Right.
Justice Hoffman denied that. As to the tick bites, he wrote to the doctor, and the email is in the record. My daughter has tick bites. What do I do?
And there was something about surgery. She was going to have surgery, and apparently she also missed her pre-kindergarten graduation.
They were on a trip. They were on a trip for the pre-kindergarten graduation from 2023, and it wasn't a graduation. It was like a little cookies goodbye. You're out of pre-kindergarten.
It means a lot in pre-K.
As to
It's a major event.
But
it was more so, I think, in terms of the surgery, right? There was an issue that he was not told, or he did not know about this. The surgery was taking place the next day, and he never gave permission or something like that for
That was from
surgery?
2022. It's not even part of motion sequence 2 or 3. That was from 2022. And he did consent. There was issues as to, did she really need it? Did she not need it? He had his concerns. He had to do his due diligence. But again, that was from 2022. And he
You're
didn't.
actually, he's actually appealing from Judge Perlman's decisions, not from Judge Hoffman's.
Correct.
But all of these incidents are in the record as to why sole custody should have been granted, right?
No, sole custody should never have been granted.
No, I'm saying this was the basis for the argument as to why
That's one of their claims, yes. But he didn't obstruct the surgery. If he obstructed the surgery, that's a different issue. Didn't obstruct the surgery. I also want to briefly touch on the status quo of what these
He ended up consenting to that surgery, didn't he?
Of course, yes. I also want to briefly just touch on what the status quo of the children's schedule has been. They've been with their father 6 out of 14 nights since September of 2023. They have been with him for the summers since June of 2023, 7 out of 14 nights. Emlyn wants more time with his father. To disrupt his access time now after 2 years, I think would be terrible for these children. And I also want to point out motion sequence 5 that was filed in December of 2024. Emlyn, the boy, is barely mentioned. He's barely mentioned. She makes no showing as to why custody needs to be changed for him. There's no mention as to why it would be in his best interest if custody was changed. Why? Well, there is no showing on any of that. The family court didn't need to have a hearing. She didn't make the evidentiary showing. Trial court. The trial court was also familiar with this family from the serial motions that she had filed. Oral argument was in July of 2024, October of 2024, and then in December we put in an affirmation, a limited affirmation in opposition to the interim relief that they filed, and then we had oral argument again in February. He didn't need to hold a hearing.
Thank you.
Your Honor, there's a couple of points. Justice Friedman, I think that you said he consented to the surgery. The fact of the matter is that he didn't consent until 24 hours before the surgery.
But he said he didn't know about it.
He wrote
He said he didn't know about it, and then he actually spoke to...
Yes, well, that therein lies an
And
issue.
he acted
didn't
promptly
know
once
about
he did get to know
a
about it.
pulmonary air passage difficulty that his daughter had to the point where surgery was being recommended, and he claims he didn't know about it. And he doesn't say that in his letter to the appellant. What he says in his letter to the appellant is that I don't believe the surgery is necessary, and I want you to read this email to the surgeon before the surgery, saying I consent to the surgery. However, I believe that they are only doing this surgery because they want to help themselves financially. And after the surgery, it was determined that she had a significant blockage. She had to be on a heavy dose of very aggressive antibiotics for 6 months. It's not only the issues that he creates through his through the injuries that the children have suffered. It's that he doesn't seek medical attention, that he doesn't give medication, that he believes and has made it clear that he believes that he knows as a scientist better than the doctors. There's another issue, which is we're confusing two things. My client has not asked for sole custody. What she has asked for, decision-making authority, sole decision-making authority when it comes to medical decisions for the children, because the father has shown that
Denied her request to modify the party stipulation to award her sole legal and physical custody of the children.
Okay. She's only asking that his access be brought back to the 4 out of 14. They had a schedule of a graduated...
Aren't the kids... counsel indicated that the children are used to this schedule. Wouldn't it be horribly disruptive to the children? I know the parents aren't getting along very well, but wouldn't it be horribly disruptive to the children who've been doing this now for several years, apparently, to disrupt that schedule?
Justice Kapnick, in motion sequence 5,
yeah,
there are at least 6 letters from medical providers, the therapists, the educators, saying how poorly, in particular, my colleague says there's nothing in the motion sequence 5 about the boy, Emlyn, only about the daughter. The boy's therapist, Dr. Keto, has made it clear that he will speak to a forensic, but he will not undermine his therapeutic relationship with his child, but there are issues. With regard to the daughter, she has panic attacks, she has separation anxiety. It's all documented in there, saying she does not have enough time with her mother, and she's afraid of her father and to express her position, her feelings to her father about the activities that he makes her do, and that she's not feeling well because she's afraid of his reaction. At the very least, on the issue of what is the best interest of these children with regard to an access schedule, there should have been a hearing, and there should have been the reappointment of an AFC who specifically said, when she appeared on the record in October of 2023, that the father is undermining the joint legal custody provisions by challenging a PC. And on the PC issue, the original PC, Dr. Kuchik, was willing to come back into the case. And right after the decision on motion sequence 4, within 7 days of the record decision from Justice Perlman, Dr. Kuchik wrote a letter saying, I decline to act as your parent coordinator because counsel for the respondent and respondent have challenged my retainer and seek to take matters out of my retainer that are the same exact provisions as was in the Dr. Heimowitz retainer.
Thank you, counsel. Thank you both. Last but not least is Peters v. D'Angelo.
Good afternoon, Your Honors. May it please the court. Beth Gehrig for the plaintiff appellant. I'm not going to sit here and claim that plaintiff didn't do anything wrong because obviously a mistake was made. And I'm not going to sit here and claim that the city was obligated to bring it to their attention because they weren't. But I am going to sit here, and I'm happy that the courtroom is empty, and I'm going to plead. Equitable estoppel is real. The courts recognize that attorneys are not perfect and we make mistakes. And here, when we look at who's really injured, it's the plaintiff. There is absolutely no prejudice to the defendant in this case. The city did a full and thorough investigation at the scene of the accident where the plaintiff was rear-ended by one of their police officers and sustained horrible...
Is prejudice even an issue?
It's not an issue per se, however, it's something that the courts have looked into when you're talking about 2001 and when you're looking at whether or not equitable estoppel should come into play. When we look at equity and fairness as in large way, we do look at prejudice. If instead we're just looking at the technical aspects of equitable estoppel, we're looking at whether or not there was negligent conduct which misled the plaintiff to believe the service of the notice of claim was of no moment. Here, the clerk who filed the papers, she said she didn't realize anything was wrong in opposition, and I think it's interesting here to point out how this first came to light. The plaintiff's counsel had no idea that anything was wrong with the notice of claim. They moved for summary judgment on the pleadings. And when they moved for summary judgment, then they were faced with a motion to dismiss. And that's when they first said, what do you mean notice of claim wasn't served? And when they looked into it, they found out that the notice of claim, which had been sent by email to the city, was actually the wrong notice of claim. And in prior instances when that happened, the city had responded and said, hey, you guys sent me the wrong notice of claim. It's not something they were obligated to do.
Not at all.
I agree with you.
And that's your argument. You kind of hang your hat on the fact that, well, you know what? They did it in the past, and therefore, they should have done it this time as well.
We're not saying they should have done it. We're saying that because they didn't do it, it's understandable why the plaintiff didn't know something was wrong. And we're sitting here and we're saying the attorney messes up, but the real party of interest here, the plaintiff, is going to lose her.
Right, and it's sad for the plaintiff, and you certainly feel, sorry for the plaintiff. But again, this is something that the statute talks about 90 days plus, 90 days plus the 6 months that expired, right?
Yes,
6 months earlier. And also I found, reading the papers, I kind of thought it was interesting. Because you're saying, well, we've done it in the past, so plaintiff's counsel had done it in the past, and the city always corrected our errors. I'm thinking, well, that's not necessarily a good thing, that this is not the first time that this has occurred.
I am not disagreeing with you, Your Honor, but I'm sitting here and I'm recognizing that Miss Godfrey Peters has horrific injuries. And as a result of the accident, there was a full and thorough investigation by the city, and recognizing that we like to resolve cases on their merits, there are opportunities here if we want to look at equity and fairness.
I'm just curious. maybe I'm missing something, but normally we don't usually apply equitable estoppel to the city of New York. Is there, is there any precedent for the position you're taking here?
Yes, we've cited to several cases in the papers where equitable estoppel has been applied.
In this context, where you waited, under these circumstances, we reversed on, or this court, was this set of circumstances elsewhere where we should be giving the relief you want?
Under Lomax, they said basically if the municipal defendant had timely access to the information by other means, the complaint should not be dismissed. There were cases involving...
Yeah, but a notice of claim is a very, it's a condition proceeding. It's a big deal, and you have to file it within a certain time, and if you don't file it within a certain time, you have to move within a certain time to seek leave. You understand that?
I recognize this, and we recognize this. Just looking at everything in the big picture, if there is any opportunity to apply the principles of equity and fairness to protect the injured party here, who is the plaintiff, I come before the court and I'm asking that if you could find it in the law to be able to revive this case and allow her to have her day in court, that is what we believe would be just and equitable.
Thank you.
And I'm willing to waive my time on rebuttal because I understand the court's position.
Thank you.
Good afternoon, Your Honors. May it please the court, Amy McCampbell on behalf of the respondents. Your Honors, this court should affirm the dismissal of plaintiff's case, which was filed without a timely notice of claim. In this context, where plaintiffs are seeking to equitably stop the city from asserting that a timely notice of claim wasn't filed, there's a well-established test from Bender and its progeny, where courts look for some kind of affirmative wrongdoing from the city and the plaintiff's reliance on that action. And here, there was no affirmative wrongdoing whatsoever from the city. It was purely the plaintiff's own mistake in misfiling the notice.
So we're looking at notice, right? So the issue is notice to the city. Was the city on notice as to the claim, right?
Well,
to some extent.
The accident did involve a city police officer, Your Honors, but again...
So you were aware of this? I mean, there were...
you did an investigation. The city...
Right, the city was aware. You had a full investigation, so you knew what was going on. You knew what occurred.
Certainly, but those factors about actual notice and prejudice, those are factors that courts consider when considering whether to grant leave to file a late notice of claim. And here, plaintiffs had
passed that.
Exactly. And plaintiffs concede in her brief, the only avenue for her case to proceed is if this court is to find equitable estoppel. That's a very high bar. She hasn't come anywhere close to meeting it. And the allegation that there was no way of her knowing that the notice of claim was misfiled is patently false, because all you need to do is look at the email on the record to see that the attachment has someone else's name. You don't even have to open the attachment to see that. So anyone could have checked. Anyone could have seen it. There was 90...
The subject line, I thought the subject line had her name.
It did, Your Honor, but
the attachment
had Figueroa or something.
It's just unlikely. Why would you look at the attachment? The other thing I think you put in your papers is there would have been a request for 50H, and there was never a request for 50H, right?
There was,
obviously.
Yes, Your Honor, and also the city, in its answer, we denied that there was a timely notice of claim served. Plaintiff apparently never investigated that until we opposed her motion for summary judgment. So there were, and plaintiff again waited till the end of the notice of claim period to file the wrong notice of claim, or till almost to the edge of the statute of limitations period to file her action. So there were a lot of mistakes that plaintiff made here. The city had no affirmative misconduct, and there was nothing to show that the plaintiff in any way relied on any action from the city here. And unless Your Honor have any further questions, we'd ask this court to affirm.
Thank you.
Thank you.